Welcome to Commercial Real Estate Unfiltered, the podcast that takes the mystery out of commercial real estate and makes it accessible for everyone. I'm Caleb David, a broker, investor, and community builder with over a decade of experience helping businesses and individuals bring their visions to life. Here we break down the market, share expert insights, and talk about the opportunities that commercial real estate creates for businesses and communities alike. No fluff, no gatekeeping, just real, unfiltered conversations that empower you to navigate the space with confidence. So whether you're an investor, a business owner, or simply curious about commercial real estate, welcome. Let's dive in. Welcome, everybody. Welcome back to the Commercial Real Estate Unfiltered podcast. Today, I'm joined by attorney Ryan Briggs, and he's an accomplished attorney based in Denver, Colorado, and he's also licensed in Utah and North Carolina. He practices at Steele Adams Hosman, and Ryan brings extensive experience in real estate law, particularly in commercial leasing, tenant improvements, and complex agreements like subordination, non-disturbance, and attornment agreements. And that's also known as an SNDA. With a sharp eye for issue spotting and a practical approach to both landlord and tenant concerns, Ryan is a trusted legal source in the commercial real estate space. Ryan, welcome to the show. Thanks for being here.
Thanks for having me, Caleb. Happy to be here.
Yeah, let's just jump in. Obviously, your resume speaks for itself, and you and I have worked together. We were actually right before the call discussing my clients who is working with you, two of them that are working with you right now. But maybe give us a little bit of background, like how did you end up in real estate law? And the second question is, how does a real estate law attorneys differ from a regular contract attorney?
Yeah, so both good questions. So going back, my background in the law started all the way even back in law school. Your second and third year of law school, you get to curate your studies a little bit more. You're out of your basic required classes. And I knew that I was interested in corporate work and real estate and representing businesses or stuff in the business world, contract law. And so that segued into doing that in life after passing the bar. And so I was working initially out of law school at a small firm where I touched a lot of real estate stuff and just smaller transactions and finance transactions and deeds and leases and all these different concepts. And so that was really my start in figuring out, hey, here are the rules of the road. Here's what it's like representing landlords. Here's what it's like representing tenants. And then that just moved forward and elevated from there. I worked at a 600 attorney firm at one point, doing really big deals that involved really big real estate finance. What's funny is in that part of my career, I actually worked with this really great attorney who's now in Denver, a guy named David Plants, fantastic friend. And I consider him a friend and a mentor. And we worked at that 600 attorney firm together back in Charlotte, North Carolina. And then I took a little hiatus at one point and did 5 years in the Air Force as a JAG officer.
Okay.
And then when I was getting back out, I knew I was going to come back into private practice. I knew I was going to continue what I was doing. And so I called David up and said, hey, man, let's see where the market is. Tell me what you've been up to, all those things. And ended up working with him again here in Denver. And then just recently left that. And as far as the first question is concerned, I kept that going. And where I was going with bringing him up is he was a mentor and a really good guide for me in the real estate world with real estate finance and everything that comes with it, because we were reviewing leases and we were negotiating those things and SNDAs and all across the board as far as the application of real estate law, so to speak, with those clients. So that's a long and convoluted answer with that, but there's a lot of touch points that I've had over the years in real estate law.
Love that. I know, and I've only learned this since being in commercial real estate now for about 11 years. And I think a lot of people think an attorney's an attorney, right?
Yeah.
And they've got a friend who's an attorney or whatever. How important and why is it for a tenant or a landlord to engage an experienced real estate attorney?
I think it's really important. It's always going to come off biased from my perspective, right? Because I get paid to tell people it's important and why it's important. The fact is, though, my goal is always to best represent my client's interests.
Yeah.
And that stays true no matter if it's a huge corporation that's entering into a lease or if it's a mom and pop shop. I want to make sure that at the outset that they are getting represented in the right way, and that somebody on the other side, because the question of sophistication, and I'm sure you've seen this, Caleb, the question of sophistication always comes in. And
Yeah.
this is not me talking bad about people who would be considered less sophisticated in the real world or with these types of transactions. It's just the reality, though, that if you haven't dealt with something,
Yeah.
you're
You
not
don't know
going to
what
be
you don't know.
yeah, you don't know what you don't know. And I tell my kids that all the time. You don't know what you don't know. It's nothing to feel bad about. And so bringing somebody in that's an expert that can help support you, tell you
Mm.
what to look for, tell you what to worry about, I think is really important. And my mantra always is, and I tell this to clients, is the earlier the better.
Yeah.
Because you get me in, then we can avoid things down the road that might come back to bite you.
Yes. And I think the cost of having an attorney is far less than what the damage could be down the road. And I
Yes.
think this is really an investment in a tenant or a landlord's protection more than
Hmm.
anything else. And I try to make sure my clients see it that way as well. So you talk about what to look for and what's some issue spotting in commercial leasing, like just very broadly.
Yeah. From a broad perspective, so some things that I always look for is at the outset, I want to know what the client's doing.
Mhm.
What is their purpose? What's their business? Because that is going to drive the train potentially in a lot of different ways.
Yeah.
It could be a very different lease if you're dealing with a retail space versus somebody in the healthcare, a doctor's office, a dentist's office. And so that at the outset is one of the big things that I look for. Now, when we talk about getting in early on, the two things that I always get initially when I'm reviewing a lease and when I'm looking for it and when I'm advising clients is the LOI,
Yep.
the previously agreed upon terms, whether binding or non-binding. And then I always get the lease itself, right? And I want to compare those two. I want to make sure they match because this is another thing that I wish people, maybe I'll say it this way again, you don't know what you don't know. So it's not bad on them if they don't know this at the outset, but the business terms of a lease are always going to be to the discretion of the business owner.
Yeah.
So I'm here as a legal representative. I'm here to help negotiate. I'm here to fine tune certain things and to help protect your interests. But from that perspective, especially if somebody has entered into, let's say, a binding LOI
Mhm.
and they did it months before I came on, then my advice on something that I may have advised them against, if they end up saying, okay, I want, based on your advice, now I want to change that, that could be a material retrade of the deal. And then we're in that neighborhood of, well, now it might get somewhat adversarial, and we don't want to be in that boat. And so the LOI I'm looking at, and I guess let me just say this on LOIs. If it's going to be a non-binding LOI, I would almost rather it be bare bones
Mm.
than overly comprehensive,
Yeah.
because
Yeah.
then we don't get into that potential material retrade discussion,
Yes.
because we're going to be negotiating everything at the lease stage.
Yeah.
And then so everybody expects there to be some back and forth at that point.
Yes.
And so that's some of the stuff I'm looking for at the outset. As far as just leases in general, issue spotting, red flags, I'm looking at it. We'll go to a triple net, for instance, right? If we're doing triple net versus gross, we'll go to a triple net. I'm looking at operating expenses. I'm looking at how those are defined. Is there an audit for the client, the tenant?
Yeah.
Is there a cap on expenses that the landlord can control?
Yeah.
Some of those being like janitor service, management fees, snow clearing, things, especially in Colorado
Yeah.
and Utah. So by and large, and let me just give it a 10,000-foot view, because I could go in depth into each of these. We could talk about the provisions where we've seen these things go wrong. But from a 10,000-foot view, I am looking to make sure that the bargaining power stays somewhat status quo, even between the landlord and the tenant. Because what I found on the tenant side is that a commercial lease, unlike a residential lease, is not, you don't have the same bargaining power necessarily. Commercial landlords, they want to contract as tight as they can to protect their investment. And oftentimes that means some lopsided provisions in leases that do not work to the benefit of a tenant.
Yeah.
And so I want to swing that pendulum back to the other side for the tenant to be able to have some rights
Yeah.
that if they find themselves in a position, because at the end of the day, they're running a business.
Yeah.
And that business needs to thrive. It needs to not be interrupted. And if it is, there's some reasonable things to ask for.
Yeah. No, I think that's really great. And I'm actually negotiating a lease right now in a letter of intent with a client of mine who's the landlord. They manage their own property. It's the only property that they have. And
Mm-hmm.
this is actually different than what you and I talked about earlier. It's another client, and they just recently, not even a year ago, resurfaced the parking lot. They get a notice 2 weeks ago that in 3 days they're redoing the parking lot again. That is a cost that's getting passed through to them. And every year they've had to pay
Mm-hmm.
thousands of dollars. And this particular landlord doesn't change the triple nets for the following year. They ask for a lump sum within 7 days of them
Yeah.
providing this new thing. And my current client, and we're renewing in the same space of a space that he took over from somebody else. So the lease was assigned to him. So
Okay.
he didn't have any negotiating power. So now we're back at it and having to deal with going back to sophistication. That can be on the landlord side too, is them not understanding the process. And instead of this landlord doesn't understand that in order for me to help keep this client in his building, he needs to cooperate. And
Yeah.
but they refuse to pay any commissions, even though I'm getting them an extra 6 years of lease instead of them losing the tenant. They're refusing to do it. In a situation like that, my client's now going to have to pay for it.
Yeah.
And we're going to
Hey,
save them tens of thousands. But these are situations that do come up from time to time.
there's a couple of things there you said that I think are important. Number one, I would recommend to any new business owner that is going into their first commercial lease to be ready to walk away,
Yeah.
to have that kind of mindset when going into negotiating, because you can be backed into a corner, like you just said, where you don't have a lot of options. There's another thing. It's interesting that you brought up the assignment.
Yeah.
So on the corporate side of my practice, that's something I deal with a lot that kind of overlaps with my real estate practice. And I get asked that question quite often about, hey, we just bought this business, we're buying this business, and we're considering a lease assignment. What's your recommendation? Should we just get an assignment of that lease? Should we enter a new lease? And my recommendation, it's a little more nuanced than this, but my recommendation is by and large, hey, let's negotiate a new lease.
Yeah.
Let's get it up ground floor, all
Yes.
those things that you and I just talked about of let's make sure you're happy with the terms. Otherwise, you are stuck with the previous negotiation
Yes.
for whatever term you agree to.
Yep.
And I think, and that's it's a hard spot to be in, but it's a balancing act because these business owners, they have to balance what their options are
Yeah.
to keep their business running versus what negotiation leverage they would want.
Yeah. No, I 100% agree. When I deal with a situation where there is, whether it be a sublease or a lease assignment, I always try to push for and have an
Mm-hmm.
attorney that I work with to really just try to negotiate a clean break, just start from
Yeah.
scratch and go through the process. So a huge part of lease negotiations is tenant improvements.
Yeah.
Clients that all the time they're like, the landlord's going to do this for me. Not necessarily. I tell people all the time it's negotiable. You're going to have
Mm-hmm.
some landlords that absolutely will not do anything, or some that if it's more of a national chain or they've got really good credit, that they will take a bigger risk. But what are some things that you've seen on the tenant improvement side from a tenant and a landlord's perspective? Maybe some things that people should be aware of in regards to build out.
Man, that's a great question. So I have seen every size, shape, form, what have you, of tenant improvement work letters and leases. And I've seen some that they're just not there. It just depends. Again, we go back to this question of sophistication. If it's a really sophisticated commercial landlord, like you said, who is an institutional across the nation, they're going to have a very robust lease agreement, very robust work letter. And that can be good or bad depending on how it's written, because as far as for the landlord's perspective, they're wanting to make sure that they have full control over the improvements that are happening, that the lease is going to start on time. The first thing I always look for in any kind of tenant improvement situation is, what is the commencement date? So when does this lease commence? Now, and I've had clients in the past who have not been good at reviewing that piece. And I've come on to situations after the fact where they are they've been paying rent for a year and the tenant improvements are still not finished and they don't have the space.
Yeah.
That is not a good place to be for any business. And it's not, and I don't think it would be sustainable for most businesses, to be quite honest.
Yeah.
And the commencement date's really important. And from a tenant's perspective, they're looking for the best situation possible, because if you have to go in and refurbish or just really do construction, especially if it's full construction on a space, you want to have the time to be able to do it, to get your doors open without full blast into rent. If rent is $20,000 a month and you've got operating expenses on top of that and additional rent expenses, security deposit, if construction's going to take you 4 months,
easy,
you don't want to be paying that. So along with the tenant improvements, we're negotiating free rent periods. We are negotiating, a limitation on payment of operating expenses during those times. And we are trying to make sure that the numbers make sense. One of the things that with timing that really comes, actually, before I say that, let me get back to, so commencement date. So the best case scenario for a tenant is that commencement doesn't happen until substantial completion of the improvements. And so we need to make sure those definitions are set in the lease. And some landlords will accept it, some won't. From a landlord's perspective, I can understand saying, hey, we're okay with that, but we need to have an either or. It's going to be the later of, or I guess the earlier of 6 months from now, or substantial completion. They want to make sure that the tenant is incentivized, especially if they're the ones controlling the work. But that's another issue in and of itself, is who's controlling the work, who's managing it. So something to pay attention to as well, and that can change based on that. But as far as that's concerned, and the deadlines, what I was going to get to is that in the work letter itself, really important to pay attention to the deadlines for approval, right? Approval of plans, specifications, final plans, what that turnaround looks like, what the obligations are. Most landlords that I've worked with are going to include what are called tenant delays. So it's usually a 1-for-1, that if the tenant is doing something that's delaying the process, they're going to be held accountable for it. I very rarely, so I started implementing this into my practice, and I've been successful with it, I would say about 50% of the time. But when I represent a tenant, I mirror that language and put in what's called a landlord delay. So that, again, so I can bring it back to the status quo that, if the tenant will agree to be accountable to whatever delays that are on them, but the landlord needs to do the same. And again, I've seen situations where landlords are completely one-sided on it, and they are holding the tenant accountable for up to $100,000 of operating expenses, but 80% of the delays were from the landlord side. So there's a concept as well. One more that I'll point out on the work letter is I think it's really important for us to have a working knowledge. And when I say us, again, this can come down to who's managing the build out. But for us to have a working knowledge as a collective, whoever we're representing, as to how long the construction is going to take. And so the local permitting, the ordinances involved, construction, get a GC in there to maybe quote it and really give a solid idea of how long it's going to take, because then that's going to help us judge. Now, along with that, though, in the bigger leases I always implement language that requires the landlord to bid out the work if they're the ones running it. And so bid it out to at least 3 GCs. And that way you can get competitive pricing. I've found myself in situations representing tenants before where that bidding process was delayed, the work was delayed, and then the tenant finally got so frustrated, they were like, you know what? We're going to go out and bid it ourselves because we don't think these bids are competitive. And they did, and they saved themselves $150,000 in the process. And so how deep you want to dive in, it just depends on the lease. It depends on the relationship, but those are examples of where you can.
Yeah. And I've had clients before that became developers and building owners that also started off in construction. You've got, in a case like that, and thankfully this particular one is very trustworthy, it's almost like if you're not paying attention, they can end up double dipping. So if the owner also has their own construction division, then you should 100%. Now, and I include GCs that I know and trust, and usually have at least 2 come out when I'm dealing with clients that are We haven't even got to an LOI stage yet, but we know
Yeah.
what's coming because it's just exactly what you said is the timing is got to be precise and defined because otherwise it have had the exact situation that you talked about where they're been paying rent for 6 months. The work's not done. They can't even be open for business. So
Yeah.
that's the cost of doing business if you do not hire an expert.
I when I get that LOI in and it says we have a 3-month window to do the construction, that's the first question I ask. I call the tenant, I say, hey, how long is this going to take?
Yeah.
And generally, especially when I'm dealing with the less sophisticated clients, what they'll tell me is they told me it's going to take 8 to 10 weeks.
Right.
And I'm like, do you think that's enough wiggle room? Because I don't.
Yeah.
And that's where we start that conversation of, hey, we need to get this defined.
Yep. And contractors run into things that they don't know about a building until they get into the space.
Yeah.
If the space is not up to current code and you're doing a change of use with a different tenant, those are all things that will then be added to. So it's important to have that contractor that understands the change of use, the real timelines, like you said, the building permits, all of that.
Yeah.
So let's move on a little bit to the subordination, disturbance, and attornment agreements. I'd love to, that's something that I'm not as familiar with, so I'd love to learn more from you on that.
Yeah. This is more of a niche leasing issue. And I see it in some and I don't in others. But essentially what an SNDA does is that it's a three-party agreement. So it's an agreement that involves the landlord, it involves the tenant, and it involves a potential lender or somebody who might step into the shoes of the landlord.
Yeah.
And so a situation where this might come into play is if your landlord has a loan, a mortgage, right? And they have this lender who, if the landlord defaults on their loan, the lender would take over the property. And if that happens, that can absolutely blow up the world of the tenant, depending on the circumstances. And I've seen this come into play in a lot of ways. So at my last firm, and I'm at Steele Adams Hossman now, and it's actually great because I work with my best friend of 20 years. Well, we had always joked about going into practice together. So this just happened 2 years ago now. But when I was at my last firm, we had a big institutional client who was a lender. And that lender would send us and we'd get probably 2 or 3 a week. They would send us SNDAs to enter into with the tenants. And so we'd always negotiate these with tenants. But some of the items and some of the issues that would always come into play would be, okay, what happens if the landlord defaults and the tenant improvement allowance isn't paid?
Yeah.
It's a good question, right? That could royally mess up a tenant's ability to get those things. Any advanced rent, generally speaking, those SNDAs are going to say, hey, the lender's not obligated to honor any advanced rent that was paid. Offsets, termination rights, those are always at issue in SNDAs. And it's really something that, although it's a standard provision in a lot of big commercial leases, it's probably something that doesn't get critiqued a lot in the way that I've seen it. And based on my experience, especially with that institutional lender where I was dealing with those on a weekly basis, I think it's really important for tenants to pay attention to those. And what I've seen landlords try and do, and I hesitate to say it's sneaky, right? Because I have represented both landlords and tenants. So I get that both sides have their positions. But it is a little bit of a sneaky way to do it where they will include those issues I just named, right? The offsets, the termination rights, the TI allowance, all those things. They will include that as a provision in the lease. So this hasn't even become an issue yet. There's a lender in place. No defaults happen. The landlord is the landlord. So we're having to think 5 years down the road when a potential default happens. But they will include those same provisions that I saw in our standard SNDAs with the lender, where the tenant would basically sign that and say, okay, I don't really know what this is, but they're signing their rights away without any ability to negotiate that in the lease. Or at the stage where it would become an issue. So let's say 5 years down the road, the lender defaults or the landlord defaults, the lender sends the SNDA to the tenant and said, you got to sign this, right? there's no ability for the tenant at that point to negotiate because essentially they've already agreed to the SNDA, if that makes sense.
No, it does make sense. And so I guess that would it be accurate in saying that in a situation like this, just because you have a lease in place does not mean that it's completely enforceable? Because it's just a situation that,
Yeah, it potentially. I think that argument can be made.
yeah,
An easier way to approach it, I think, from my perspective, and this is the way I operate with my practice, is that if I see that language in there, it depends on how robust the most robust one I've seen is essentially an entire SNDA within the lease.
okay,
And that's rare. So if that's the case, I'm making all of those tenant comments that we would always see on the lender side about offsets, termination rights, TI, just to make sure that those are in place.
right,
If it is not that, right? I am whittling down that provision in the lease, or I'm including language that gives the tenant the ability to make reasonable comments and negotiations to the SNDA in the future. In my opinion, that's, I think, the best way to address it.
yeah, that makes sense. I know we got into the weeds a little bit there, but it was like
Yeah.
super interesting to me because again, like I said, this is newer to me. So we'll go back a little bit more on a broad level, but what are some of the most important issues that a commercial tenant can look for in a lease?
Yeah. So I really do think that their rights to abatement and termination are two of the most important. And that those are two that I push quite often. I'll give an example. This will be a little more fun than me talking about specific language because I'm nerdy, Caleb. I know you're nerdy. We like to dig into this stuff. But so had a client who the lease specified that maintenance obligations for the landlord included HVAC. That's a pretty standard lease provision. HVAC went out. Landlord did not comply, did not fix it, took no commercially reasonable efforts to fix it, those types of things. In this specific case, though, the way that the lease read was a little wonky. And there was, aside from litigation, which is really costly, it's really expensive. I just had a case that I litigated, and I don't do much litigation. I was supporting a partner in this, but the week of trial, we probably, let's just say that the legal fees were in hundreds of thousands of dollars. So just to put that in perspective. So if you're in a situation where your lease is silent on something, but it's something you consider a material breach, but that means that your only legal leverage at that point is to litigate, to file a lawsuit against the landlord. Nobody wants to do that. It's costly, it's time consuming. So in this case, though, so going back to the provisions, one of the provisions that I always add in is that, hey, the landlord has certain obligations. Let's highlight those.
Yeah.
If they don't meet those obligations, let's give them a time frame to meet them. And typically what I propose is 5 days. Yeah. And I think about it in this perspective from a business owner. If your shop is closed for five business days, right? Essentially is what we're talking about. That's bad. That's a lot of revenue lost. Inability for a lot of companies to do any work if that's happening.
This is interference.
Yeah, it's an absolute interference. And so if that happens, then the abatement comes in. And it should be, again, if you're not using the space, it should be abatement of rent. It should be abatement of additional rent. It should be abatement of operating expenses, however those things are defined. And that's another thing to just pay attention to. How are those things defined? Because we think of rent as rent a lot of times, but there are so many other little add-ons that can happen in the lease. And so going to the termination right piece, what I always tag onto that is that, hey, if this failure continues, and at a starting point, I will sometimes do 30, I will sometimes do 60 days. But if that failure continues for that long, the tenant should have the right to cut their losses and say, hey, we're going to elect to terminate because you guys haven't fixed the problem. We can't run our business. We got to move forward. So and this kind of overlaps with what we were just talking about with the SNDA. So often, landlords do not want any termination rights in a lease. They don't want the tenant to have any kind of out. But I think it is so important. Another place I see them try and sneak stuff like that in is the boilerplate black letter provisions that you see in every lease on casualty. So if a fire happens, burns down the building, then I have been surprised at some leases recently where the landlord is basically saying, "Hey, we're not going to allow you a termination if that happens." And it's market standard too, right? That if it takes the landlord too much time to potentially rebuild the premises, they need an out. And so those are the two big ones, right? Abatement of rent and expenses and termination of the lease itself,
Yeah.
just to be able to give them options to be able to then go run their business elsewhere if they need to.
Yeah, and I think something that you touched a little bit on CAMs and triple net expenses, all of that sort of thing. Another reason it's important to look at what those things are and what they cover, then you got to think about what does it not cover. There are some leases that they include quarterly or biannual HVAC cleaning and they pass it through the triple net.
Yeah.
Or you have to pay attention. If it's not included, then they're expecting you to do that. And that's going to be a cost that you take on.
Yeah.
And in one of the leases that you and I are working through right now, there's that really strange language. I thought at least it was strange that the landlord refused to do any work at this $8,000 limit, right?
I've not seen that one before.
I was just like, this is ridiculous.
Yeah, and we were talking beforehand about, and maybe it bled into this conversation, but the sophistication of the parties. And when you have a landlord who's maybe a one property owner, when we talk about things being market, sometimes they just don't abide by that. They don't care to. It's not their primary business. Or if it is, it's just the one property. And so they're not worried about finding tenants. And yeah, I think you've always got to watch out with CAMs. There's always going to be typical things that are appropriate that can pass on to the tenants of the building. You want to make sure the percentage of the share is fair, but then there's also stuff that should be excluded that can be potentially abused by landlords. And particularly management fees is one of those.
Yeah.
I always try and limit that to make sure that, hey, we're not talking about anybody above the level of a building manager, for instance.
Right.
You got to watch out for fringe benefits. We cap it at 5% and say, hey, 5% of gross rents, that's the most you're going to charge for management fees. And so I think I mentioned this at the outset, one of the caps that I put in place is I typically try and shoot for 3%. So I'm giving away the game here if any landlords are watching. But usually market is 5%, but no more than a 5% increase in those controllable expenses, right? The ones that they have control over, the 3 to 5% is meant to give them some wiggle room with inflation. It really shouldn't be more than that, because otherwise they're just trying to gouge the tenant.
Yeah, 100%. As we wrap up, Ryan, what are some last minute pieces of advice or things that you wanted to share that our listeners can latch onto?
All right. So this is going to be a little self-serving, but I'll start with the not self-serving part. It is so important to have a good broker. And Caleb, having worked with you, having worked with people in your office, I can tell you're good brokers. And being able to have that institutional knowledge, somebody that's doing this day in and day out, negotiating with all different kinds of landlords, is so invaluable. And so, as you've seen, when I am working on a lease, I want the broker involved in the discussion on my comments. And because they have a great perspective and they can provide maybe some insight that me as an attorney that I maybe don't have that perspective. I became an attorney because I'm risk averse, because I'm somewhat rigid in my thinking. And sometimes the broker perspective helps me knock out of that. So that's one, right? Make sure you have a good broker. The second is get an attorney from the outset. If you think, hey, I'm probably going to need an attorney down the road on this, do it right at the outset.
Yeah.
Because that's going to save you time. It's going to save you maybe some heartache in the negotiations, depending on how those play out. And I think that is really important, because there are good attorneys out there who want to help you and want to do right by you. And I guess when choosing an attorney, referrals are really important. Getting that from somebody who knows them, who's worked with them, because a bad attorney, just like a bad broker, I'm sure you've seen the same thing, can really screw up deals.
Yeah.
And I've seen deals fall apart because of those professionals who are involved who just muck it up for the parties.
Yeah, no, I completely agree with that. I mean, I think what we do is a team sport. We all get paid our own separate ways, but I think it's so important for us to look at this because, like you said earlier, you have to work with lenders as well. This is a multifaceted industry, and I think we
Yeah.
need each other to work together. So, Ryan, where can people find you? How do they reach out to you and how do your consultations work? And we'll close after that.
I'll start and just say consultations are free. I know, and if you want to consult with me, ask questions, I'll give you an hour of my time, no problem. We'll talk it through. I'm not going to charge you. Localcounsel.legal is our website. You can get my contact information there, and happy to discuss any legal issues. I always tell people this. If you have a question, whether you think I'm the guy or not, just ask me, because I have a big referral pool. I have people that I know, and back to that point about having somebody that is referred that you trust. I have those people that I've worked with on a lot of different things, and if I don't have the answer for you, if it's not my niche, I will point you in the direction of the person who is.
Yeah, are so aligned in that way because I literally
Yeah,
told a client yesterday, if you think it's a stupid question, please ask it because it's
yeah,
probably relevant and will lead. And if it's not, it will lead to the right questions that we need to be asking.
yeah,
Yeah.
totally agree. So yeah, never be afraid to ask. I might not be a family lawyer, but I know some great ones.
Yeah, absolutely. It's all about the network and who you know and who you trust. And Ryan, you are one of those
Mhm.
people for me. And I appreciate your time
Well,
today. And
thanks, Caleb.
guys who are listening, if this was helpful to you, please subscribe to the channels on YouTube, Apple, Spotify, and give us a follow, give us some comments, reach out to Ryan, ask him some questions, and we're here for you whenever we can be. Thanks for listening.
That's a wrap on this episode of Commercial Real Estate Unfiltered. I hope you found value in today's conversation and feel more confident about navigating the world of commercial real estate. If you enjoyed the episode, be sure to subscribe, leave a review, and share it with somebody who could benefit from these insights. You can connect with me, Caleb David, and the team at David Commercial Real Estate. Just check the show notes for more information. Thanks for listening, and remember, creating space is more than just real estate. It's about building community. See you next time.